David Ross. He's a partner at Seyfarth Shaw. David represents companies in numerous manufacturing and service industries in almost every area of labor and employment law. He specializes in class action cases. And David, you have filed an amicus brief on behalf of Costco in this case, which is to say you're on Wal-Mart's side effectively. What do you figure is your strongest argument in favor, or at least on Wal-Mart's behalf, or what is the strongest argument Wal-Mart can make in order to get this class decertified, let's say, or to prevent it from being certified?
Well, Wal-Mart has a very strong case that the Court of Appeals is just allowing class actions with very little showing. That's all the plaintiffs showed here, was that Wal-Mart has a lot of stores all over the nation, thousands, that they relied on local managers to make local decisions, and that some of these decisions involved subjective judgments. They argued that the subjective judgments could be adverse to women, but they had no evidence of that. They were not able to show that there was any discrimination across the whole class, so that only a handful of women seek billions of dollars of damages, claiming to represent a million women at Wal-Mart without any showing that those women suffered from the same discriminatory treatment that they claim to have.
All right, this is going to the Supreme Court. It's not an evidentiary thing. It's just the strength of the argument and ultimately the court's decision. Given the makeup of the court, and this is a big issue, how do you feel about your chances?
Well, I think the chances are fairly good because you know, even the more liberal members of the court have to be concerned about whether or not the rules for bringing class action are within the proper bounds. If you allow class actions to be brought with very little showing, then companies all over the country will be facing, you know, ruinous lawsuits. And, you know, they may be, you know, forced to just make the numbers come out right, which is something akin to adopting quotas. And that's contrary to the policy of the court and policy of our civil rights statutes.
So where is the appropriate middle ground here? Clearly, the court, you know, we want protections for civil rights, and we want the court to act in the public's best interest. If you were one of these women, you would want the court to be on your side. So where is the appropriate line to be drawn?
Well, these women may have individual claims, and you know, it's easy to bring these claims. Claims like these are brought on behalf of women and minorities, you know, every day. The question is whether or not there should be a class action lawsuit, and whether a handful of women could represent millions. And there are rules for that, and they have to have to show that there's some commonality, some common thread that binds the whole class together. Here you have no showing of that kind, and the court just allowed a class action to go ahead, you know, with very little evidence to support it. So this isn't going to kill class actions in employment discrimination. It's just going to rein it in and bring it within proper bounds that the court originally contemplated, you know, 10 years ago in the Watson case.
Well, David, thank you very much for joining us and giving us what amounts to a preview of Wal-Mart's arguments to the Supreme Court today. David Ross, a partner at Seyfarth and Shaw. He's a specialist in class action suits, and he filed an amicus brief in this case on behalf of Costco, whose interests are broadly aligned with Wal-Mart's.